Do you have clients consistently running away from you or ghosting you once you have met them and then shown them your contract language? Well, then maybe it's because your contract is a little bit too scary for them. We're going to be talking about 3 ways to make your contract less scary in this video. Stick around. Out there, welcome back to Wedding Industry Law. My name is Rob. I'm an attorney representing wedding industry professionals, and you've stumbled upon the least popular YouTube channel dedicated to wedding professionals trying to keep it legal. We do all kinds of things on this channel, talking about contracts, talking about trademarks, disputes, lawsuits, you name it. If it's about the law, if it's about weddings, we cover it here. And in today's video, we're talking about what you can do with your contract if you find that you are getting pushback or people pushing back so hard they run away because of the content, because of the language that appears in your contract. So let's set aside they don't like your price. Let's set aside they don't like the cut of your jib. We're talking about ways in which you might be scaring away clients or potential clients because of how your contract looks, how it sounds to that potential client. So there's typically going to be 3 categories, at least in my experience that I've seen, and I'm doing this, it's 3. There's typically 3 categories of ways, 3 buckets where wedding professionals are messing up. We're going to go one by one.
Number 1.
So that first bucket is going to be the language of the contract being too aggressive. So it's all about what the client can't do. It's all about what you won't do. Or maybe you are really kind of reaching into their pockets, nickel and diming, or perhaps excessively billing them for something. So let's kind of flesh that out a little bit. So in terms of the aggressive nature of what the client can't do. So it might be something along the lines of do not call during off hours. Do not drop my microphones. Do not put cocktails on my equipment. Like you're really framing it as a prohibition on something. Or it might be, we will not respond to calls during off hours. We will not make any revisions after you've made a final determination. So like real conscriptive, it's extremely loud, the language in terms of the negativity in it. Or it could be, I'm going to charge you $400 for any return checks, even though it's really only a $35 fee at my bank and maybe a couple of hours of my assistant's time. The $400 is really just, I want to keep you from doing it. Or I charge a 7% merchant services fee if you pay by credit card. So like just really aggressive nickel and diming. So if you can objectively look at your contract and see that maybe you are doing these things, then that might be a red flag for some clients. Like, I don't want to be talked to that way. Like, I don't, you don't want your contract to be super snarky. You don't want your contract to be overtly hitting somebody over the head with what your rights are, right? Even though the contract is designed to do that. The contract is designed to set forth what your obligations are and what their obligations are. But there's a tactful way of doing things. And so how not to be aggressive. Number 1 is you can essentially make the language softer. So instead of saying, do not drop my microphone, you can say, please inform your guest to refrain from, negligently handling the microphone. So literally just softening the language, right? Or you can, what I find effective sometimes is alternatives. So for example, should guests desire to drop the mic, we will be happy to provide them with a fake mic. Okay. So, if there is something that you don't want them to do, go ahead and put an alternative in there. Okay. Another way that you can soften the language, not be as aggressive, is put in prefatory imprecatory language. So language that informs the client why whatever behavior you don't want them to do or whatever behavior you're not going to do, why that is in effect. So for example, it might be, wedding professional has obligations to her family during off hours and obligations to other clients on Saturdays. Therefore, we will respond to communications the next business day. So instead of saying, I'm not going to respond to you immediately if it's a Saturday, I will not call you back if it's after 5 p.m., you're explaining why that is the case and softening the language up through explanation. So that's another effective way to kind of make your contract less hateful, for lack of a better word. With regard to nickel and diming people, you might want to go back and reevaluate why you're demanding whatever the money is, whether it's a return check fee, merchant services fee, travel fees, whatever it is. Evaluate that, see if you can kind of bake that into the cake. So for example, if most of your clients are paying through credit card, you charge a merchant services fee, then maybe consider just hiking your price up a certain amount and essentially passing that cost onto the client through what you're already going to charge them. So that might be something that you want to think about. So in other words, really evaluate why you're doing it. And if you can get rid of some of those, that might be something to think about. But again, this has to do with whether or not, as a whole, your contract is overtly beating them over the head. I'm not saying that you shouldn't charge things. I'm not saying that you shouldn't be compensated for your expenses. I'm just saying that, there's a difference between reasonable expenses and just like, come on, guy, what are we doing?
Number two.
Another way our contracts are potentially scaring clients away is the language is too complicated.
You're throwing too many big words at me. Because I don't understand them, I'm going to take them as disrespect.
So heretofore, the obligations beginneth at dawn, heretofore, et cetera, et cetera. Overtly excessive legal language that you can't understand, if your contract is riddled with that, then your client's not going to understand it. If you don't understand it, they're certainly not going to understand it. So I'm not saying that you should go through your contract and dumb down language to a first grade level, but at least have language that you understand. Now, there's going to be things, there might be concepts that you don't understand, even if it's in basic language, and that's okay. Not everybody understands exactly how indemnity works. Not everybody understands the concept of limited liability. That's okay, but you can understand the words. Like, you should be able to follow it without it taking 10 minutes to understand one sentence. So, ask your doctor if that's right for you, but, so don't... In other words, don't get rid of things. You just want to clean it up so that it's readable to somebody with, a high school education at least, right? I will say this though, there is a level, a give and take, a balance. In other words, in my experience in reviewing contracts for over a decade, I feel like the companies and the businesses that try to make the language really, really, not infantile would not be the right word, really, 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 really basic. The more basic the language gets, the more likely there's ambiguity and there could be potential legal problems with what exactly are the parties' obligations, because that's just how the language works. That's kind of why, in my opinion, legal language developed. It's to plug in the holes that the average use of language creates. Like, when we're just talking normally, it could leave a lot of gray area. That's why a lot of times you see attorneys, they talk in cross-examination. They want to get right down to what the points of contention are. And that's, like I said, that's kind of what legal language does. It tries to relieve any type of uncertainty from the language of the contract itself. So there is a balance. I'm not saying that everything has to be the heretofores, whereas, recitals, all that kind of stuff, but it also shouldn't be, hop on pop by Dr. Seuss, right? So we have to strike that balance.
Number three.
Third way in which your client could be scaring away people is the fact that it might be extremely one-sided or viewed as one-sided. The client is the dumb and you are the awesome person, or the client has all these obligations and you have no obligations. That's what it might seem like to the client. So by way of example, you might have a clause that says, if wedding professional is successful in a lawsuit, wedding professional will get attorney's fees. The client will have to pay attorney's fees. Or indemnity. It might be the wedding professional is indemnified and held harmless by the client for XYZ negligent conduct. These are things that are one-sided. Or wedding professional can use photos of the client for their business without the say of the client. There are many ways in which it can be one-sided. So again, ask your doctor if this is right for you, but there are ways that you can make that flow both ways. So indemnifying one another, doing the attorney's fees, depending on who wins, for example, the other will have to pay the attorney's fees. There are ways that the photos can only be used by the professional if the client agrees. These type of things. If you go through your contract and it's bam, 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 and it's super one-sided and you're seeing that clients aren't going for that, these are ways in which your attorney can soften that image up for you. But again, if you are closing clients like gangbusters and your contract are super one-sided, good for you. But what I'm talking about with this and with the aggressive language and the complicated language, I'm talking to wedding professionals out there that might be scratching their heads. Why are people leaving me if they love me once they see the contract? This might be it. So if that's happening to you, then you might want to think about these three areas: aggressive language, complicated language, and one-sided language, as might be the culprits of why that's happening to you. Well, I certainly hope that you found this video informative. If you did, be sure to like and subscribe. If you have any ideas for content, please let me know. New videos just like this every Monday at Wedding Industry Law. With that, folks, we'll see you next time.